if you violate, she's the one who's the heat's going to come down on. Do you understand that? We will go on the record in the matter 25 CF 98, State of Wisconsin versus Brandon Allen. The state appears through Assistant District Attorney Jose Vila in person. We have Joel Feliski in person. Mr. Allen appears by video conferencing in custody in Burnett County Jail. We're set today in this matter for a preliminary hearing. Mr. Allen, I've been informed that this is a waiver of that hearing. Is that correct?
Yes, ma'am.
Did your attorney thoroughly go over with you what it is to have a preliminary hearing?
Yes, ma'am.
I see, Mr. Feliski, you have the proper document, and you've went over that with Mr. Allen?
I did, Your Honor. I went over it word for word with him. May I approach?
You may. Thank you, Mr. Feliski. So, Mr. Allen, I have this waiver of right to preliminary hearing document in front of me. Did your attorney thoroughly go over this document with you?
Yes, ma'am.
And you understand everything completely?
Completely, yes.
And you understand that you are admitting that the state can meet the burden of probable cause?
Yes, ma'am.
And you understand that once you waive the right, it's forever and you cannot get it back?
Correct, yes, ma'am.
Has anyone made any threats or any promises to you for you to waive this right?
No, ma'am.
You're doing so freely and intelligently and voluntarily?
Yes, ma'am.
I'll find that you are competent, you're freely, intelligently, and voluntarily waiving the right to a preliminary hearing. I find probable cause and bind the matter over. And Mr. Allen, this is your signature on the form, correct?
Correct, yes.
All right. Information, Mr. Vila.
I'm going through and filing them now. They will mirror the criminal complaint.
Would you like to proceed with an arraignment or set for another date?
Your Honor, if we could set for an arraignment.
How far out? Well, I can do oh no, that would be wrong week. I can do October 1st. I have a couple slots in the morning, or I can do the afternoon at 2:30.
The time at 2:30 will work, Your Honor.
All right. October 1st, 2:30. All right, we'll set that for an arraignment. All right, argument for bond modification.
Thank you, Your Honor. My argument essentially mirrors the modification request that was filed previously. The only update I really have is that I do want the court to know that Mr. Allen, it's my understanding as of yesterday, did complete the HSED program at the jail. I believe that he advised that he's actually the first male to complete the program at the jail. So he has been taking advantage of the resources available to him. He has been in custody for a significant amount of time on this case. The request for $2,500, Your Honor, is still a very, very significant amount of money. It is, I think, very sufficient to compel Mr. Allen to come back to court and to have this matter resolved.
First, before I ask for argument from the state, I just want to tell you, I am so proud of you, Mr. Allen. I'm proud to hear that. Congratulations. I really think that that is an amazing accomplishment.
It is, Your Honor. Thank you very much. Yeah, I'm very, very excited about it too. My mom's excited. She's here. Yeah, it's been a long time coming, and I wanted to thank you for that opportunity as well. Without coming here, I don't think that I would have been able to achieve that. So, I mean, now I'll be able to kind of move on with my life and pursue after schooling. Hopefully.
I'm just so glad to hear that. I'm just so happy. All right, Mr. Vila.
Your Honor, the main concern here is the level of offense that Mr. Allen is currently charged with. There was 43 grams of meth that was found on his person. If the court is open to modifying the cash bond, the state would still request a significant amount of cash to ensure future appearances. He has one missed appearance, I believe, in Minnesota from 2016. He was in warrant status for 4 months during that time, but outside of that, it looks like he's appeared for court. So.
And I'm not sure who wants to provide this to me, but what is his criminal history?
Your Honor, for my review of CCAP, I don't believe that Mr. Allen has any criminal history here in Wisconsin. The only cases I found were, as DA Villar suggested, the 2016 conviction for, I believe it was,
It's a petty misdemeanor theft case in Minnesota, Your Honor.
petty misdemeanor theft. And the only other conviction that he has on record is very ancient. It's 2011. I believe it was issuance of dishonored check.
All right. So, Mr. Allen, if the court considers modifying bond and amending it down to a lower cash, who's going to be posting that cash? Whose money is it?
As of this time, I'm not for certain anymore. When I first filed for bond modification, I had a friend that was possibly gonna bail me out. But at this point, it'd be kind of all hands on deck, if that date even came. Part of it is for peace of mind at this point and to prove to the court that I will show up for court. I think $2,500 might take me a week or two to talk with some of my friends, if I can even get in touch with them, family members possibly.
All right, here's what I'm gonna do. And Mr. Allen, you getting your HSCD is coming into play big time. It's showing me that you want to change your life and you want to do better things with your life. And I want to see you do that. This is a very serious charge. I don't know the ins and the outs. I don't know how you were allegedly in possession of 43 grams of methamphetamine. I don't know anything other than what's in that complaint. But I do know that this is a serious felony. You face 25 years of incarceration, some initial and some extended supervision. That's a lot hanging over your head. Hearing that you don't really have a criminal history, or it's just a few things here and there, not anything along the lines of possession with intent of methamphetamine at almost 50 grams, that comes into play as well. I believe in the motion, you stated that you were going to be working at the Salty Steer and living with your mother. Is that correct?
Correct. I'm not 100% certain about working because, again, a lot of time has passed. But if you look at the area that my mother does live, very few options to work are available, and they are consistent with bartending, which I am licensed to do. I got no problem with checking in with law enforcement so they can see that I'm not breaking any of the rules or anything like that. I got no problem with staying sober. I just want to get working. My daughters, I've received a few letters from child support agencies since I've been in here. They want to continue to pursue child support from me. I want to be able to attend those hearings as well. So, I might be able to try and take up a cooking job in a restaurant up the road. But like I said, with the location of where the living status is, very minimal places are accessible to work with, form of transportation.
His mom, can you please step forward? What's your name?
Deborah Allen.
Deborah Allen. Ms. Allen, do you understand that if the court does modify bond, one of the conditions will be to reside with you?
Absolutely. He's been living with me for 3 years. Since the statute.
Well, you need better supervision.
Yeah,
And so you're willing to take the risk and to supervise him?
absolutely.
Do you own your home?
I do.
So what I'm going to do is, if I do modify and amend, and then I'm going to, I don't know what amount yet. My brain needs to think a little bit, but you're gonna need to co-sign for a cash bond. I would do a cash bond with part of it be a signature bond. Do you understand that if he violates his conditions of probation, he does any criminal activity such as this or others, that you could be liable as well? Are you willing to take that risk?
Yeah.
Okay. And so if he doesn't come to court, that means that the court can convert that and could possibly go after you for the
Right.
remaining amount. You understand
I
that?
understand.
And you're willing to take that risk? Oh, all right. Thank you. You may go have a seat. Mr. Allen, do you understand the seriousness of this?
Yes, ma'am.
Do you love your mother?
More than anything,
Do you respect your mother?
100%.
Do you love your daughter?
Daughters, yes, ma'am.
Oh, daughters, sorry. All right, Mr. Allen, this is what I'm going to do. This is a serious risk because this is a serious felony and I am taking a chance on you. I will amend to a $2,500 cash bond with a $22,500 signature portion, which your mother will be signing the bond, acknowledging that if you violate, she's the one who's the heat's going to come down on. Do you understand that?
Yes, ma'am.
Do you understand she could lose her home?
I would never do anything to jeopardize that.
Okay, all right. So conditions will be absolute sobriety, no alcohol, no illegal substances, no paraphernalia, no prescriptions without a valid prescription. Other than for work-related purposes or seeking work, you may not be in any establishment that has the primary purpose for the sale or the service of alcohol, such as bars, taverns, liquor stores, beer tents, etc., including the casino. You're
I'm-
subject, go ahead.
I 86 myself from the casino a year and a half ago. So am I allowed to go in there to reapply and to try and lift my 86?
You could do that for job-related purposes only.
Yes, ma'am.
I am ordering you to random, not subject to, I'm ordering you to random testing of your blood, breath, and urine by the court's justice coordinator, Tessa Anderson, and that is a cost to you. And that would be $25 a pop. Do you understand that?
Yes, ma'am.
And again, you must pay that at the time of testing. Do you understand that?
Yes, ma'am.
And the court is doing that because I am taking a significant risk with the Class D felony and the allegations in that complaint. But I'm hoping to
can't-
give you another chance right now.
I appreciate this very much, Your Honor. And I thank you
If
for
you
the
if you test positive for any substance, your bail's revoked. Do you understand that?
Yes, ma'am.
And that includes alcohol. Do you understand that?
Yes, ma'am.
right.
Absolute sobriety.
You may not be around anyone without the court's permission who has a felony conviction. They're either on probation or extended supervision, or they have been convicted of possession with intent charges. Again, without the court's permission. Do you understand that?
I understand.
Obviously, if you're at a bar and you're serving drinks, that's fine, but you may not have any communication other than, here you go, buddy, $4. Okay?
Correct.
All right. Any other conditions the state would like to see?
Your Honor, I would also request that any known drug dealer houses or properties that he stay away from those as well, please.
All right, that will be added as well. Anything further, Mr. Vila?
No, Your Honor.
All right. So the court will amend bond with the lower cash and with those conditions before it takes effect and before you can be released. The money needs to be paid. You need to have signed the bond and your mom needs to sign the bond, okay?
Yes, ma'am.
All right. Now, we need another, we already have the date. We're all good to go. Anything else?
Nothing further. Thank you.
Thank you. Then we are adjourned.
Thank you, Your Honor.
What a remarkable hearing we just witnessed. Let's break this down step by step. From the outset, the judge was crystal clear. Brandon Allen knowingly waived his right to a preliminary hearing. That waiver is no small detail. It means Allen is conceding that the state has enough evidence to establish probable cause, By doing this, he skips one hurdle in the legal process, essentially fast-tracking the case toward arraignment. This is a strategic move often advised by attorneys when the evidence is overwhelming, and in Allen's case, the 43 grams of meth found on him speak volumes. But here's where the drama shifts. Instead of simply moving forward toward trial, the defense pivots hard toward bond modification. Why? Because bond isn't just about money. It's about freedom, preparation, and the chance to rebuild a life outside of jail walls. Allen's attorney highlights his achievements in custody, most notably completing his HSED program, the equivalent of a high school diploma. The fact that Allen became the first male inmate to achieve this milestone at the jail is a powerful narrative of change, and even the judge herself couldn't hide her pride. That moment of humanity in the courtroom was striking. Allen's gratitude, his mother's presence, and the judge's recognition of his effort all collided into a rare glimpse of redemption. Still, the prosecution wasn't letting sentiment override reality. Assistant DA Vila emphasized the seriousness of the charge, reminding the court that Allen was caught with nearly 50 grams of meth. That's not a personal use case, it's distribution territory. Vila pushed for a significant cash bond, pointing to Allen's past missed appearance in Minnesota as evidence of flight risk. This is where the tension lies. A defendant with a serious felony and heavy prison time on the line versus a man trying to prove he's more than his mistakes. Then enters one of the most emotional layers of the case, Allen's mother, Deborah. She steps forward, willing to supervise her son, even risking her own home as part of the bond agreement. Imagine that for a second. A mother not only vouching for her son's character, but also legally binding herself to his actions. If Allen violates conditions, the financial and legal consequences fall directly on her shoulders. That is the definition of parental faith, and a gamble that could either pay off or cost her dearly. The judge's ruling reflects this balance of risk and hope. By reducing the bond to $2,500 cash plus a $2,500 signature bond, with Deborah as co-signer, the court is essentially saying, "We'll give you a chance, but we're watching closely." The attached conditions are strict: absolute sobriety, no drugs, random testing, restrictions on who Allen can associate with, and even limitations on the establishments he can enter. These are not suggestions. They are lifelines designed to keep him accountable. One slip and it's over. So what does this case reveal? It shows the razor's edge the justice system walks between punishment and rehabilitation. On one hand, Allen faces decades in prison for the meth charge. On the other, he's presented as a man taking genuine steps to change, supported by a mother willing to risk everything. The judge's decision embodies this tension: cautious leniency under strict watch. Now, I want to hear from you. Would you have taken the same risk if you were in the judge's shoes? Do you believe Allen's accomplishment in jail proves he's ready for a second chance? Or does the weight of the drugs outweigh everything else? If you found this case as shocking and thought-provoking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We've got more cases coming where justice isn't always black and white. It's gray, it's risky, and it's human. Until next time, thanks for watching Courtroom Files.